Good evening, everyone, or good morning, and wherever you're joining in from. Thank you all for tuning into today's session brought to you by TiE Women. I'm truly inspired to see the number of you who have turned up to spend your Sunday learning and acquiring new knowledge. I am Shamima Parveen. In my day job, I'm co-founder and CEO of EduTech Middle East and EduTech India, a leading learning solutions organization. I'm here today as part of TiE Women. I'm co-chair of TiE Women in TiE Dubai and part of the Global Management Committee of TiE Women. Some of you already may know TiE Women, but let me take an opportunity to give you a 2-minute introduction. TiE Women is an initiative of TiE, which is the Indus Entrepreneurs, was launched in 2019 to embrace, engage, and empower women entrepreneurs across the globe, inclusive of all stages of an enterprise, origin, standing, or background. It's based on 6 pillars, which are learning, like what we are here to do today, mentoring, access to funding, scalability, creating a safe space, and community. We run a number of women-oriented programs through the weeks and through the months. The first one I would like to talk about is our flagship program of our annual global pitch competition. Some of you may already have participated in it and getting ready to pitch in your chapters. Wishing you all the best and hoping to see you in the global finals happening in Dubai in October as a part of the GTEx Future Stars. This program has grown considerably in our second year, and we are seeing the impact that it is having on women entrepreneurs across the world. The second program that we run is called the Open Mic Night, which provides a safe space for concept stage and early stage entrepreneurs to get feedback on a specific ask provided by mentors who come in to give them the inputs required to shape their business. We have very soon, next week, 11th of August, our first international open mic night happening in combination of India, Pakistan, Dubai, and New York. Please do feel free to join us, and you will be getting more information in the coming weeks from that. The third program that we conduct from TiE Women is the Connect series, which brings on stage women entrepreneurs who had large exits in their business, and also investors to talk about their experience of coming to that stage. The last one is the active learning workshops, like what we are here to learn today. It's a hands-on learning program on a number of interesting topics, like today's program of intellectual property. The other ones that we are going to come on board soon is programs like the design thinking, finance for non-financial, and others. Stay tuned to learn more. I'm now pleased to introduce the host of this event, Shabana Karim. Shabana is the owner and founder of the House of InSpa, a holding company comprising of the Nail Spa, Ispai, and Marquee. Since 2002, Shabana's positive impact on the beauty industry in the UAE has been recognized through numerous awards, including an award by Dubai Quality Group as Businesswoman of the Year. Shabana, take it away.
Thank you, Shamima. Thank you so much. Hello, everyone. I'm extremely excited to have you all attend today, first of many, as Shamima said, the active learning workshops. So for today, I will, just before that, I also would like to say I'm a TiE Charter member and part of the TiE Executive Committee. I would like to now introduce Victor Siriani, who is going to be talking to us about what is intellectual property and why it is important. Victor Siriani is the managing partner and founder at AVID Intellectual Property. He has a master's in law in intellectual property and technology. Victor has over 15 years experience in IP in the Middle East. In addition, Victor also trains lawyers and legal consultants on IP law through the Dubai Legal Affairs Department as part of the continuing legal professional development program. Victor, thank you for joining us today and sharing your experience and knowledge. And I'll pass the floor on to you. Thank you.
Thank you very much, Shabana, for the introduction, and hello, everyone. I understand there are a number of people from around the world that might be attending this presentation. So before we start, I have to make the point that although we are based in Dubai and we might speak some points about Dubai issues or UAE issues, I should say, intellectual property law on a worldwide basis is pretty much 95%, if not more, unified, because most countries have signed up to all the international agreements and treaties on IP protection, such as the Paris Convention on IP protection, the Berne Convention on copyrights. So there are multiple agreements and treaties that pretty much all countries are signatories to. You might find differences in procedures when filing requirements, but the laws are pretty much the same. So please keep that in mind, that in general, what I will be speaking about applies to almost all countries, but I will be discussing issues from outside the UAE and outside the Middle East as well. To continue, I'm gonna, for now, turn off the camera, and then once we get to the Q&A section, then I'll turn it back on. Now can you hear me? I assume everyone can hear me now.
Yes, we can.
Fantastic. So this is something that we face a lot with companies when we go visit potential clients, is we'll walk into their office and we'll see that they've spent a lot of money on the decor, on the furniture, leather couches that probably cost $4,000 or $5,000. But when we speak to them about their intellectual property, have you registered your trademark, have you taken care of your copyright, etc., they tell us, well, it's an expense, I don't want to spend that money. And in reality, that is the wrong way to consider IP. Intellectual property, whether it's a trademark, copyright, or a patent, is an asset of your company. And in our opinion, it is much more important than the decor and the furniture. To give you an idea of some of successful companies, I'll give you a couple more examples later. Victoria's Secrets, I'm sure everyone knows that company. They started in 1977, a small company with $80,000. They filed their trademark 8 months after they launched in 1978, February. And today, this company is worth $1.1 billion. Now, Victoria's Secret didn't really take off until 1982, but they did not wait till 1982 or until today to file their trademark. Had they not filed their trademark early on, anybody could have started selling women's lingerie and using Victoria's Secret or something incredibly similar to Victoria's Secret as the name for their store. And in that case, you could almost be assured that Victoria's Secret that we know today wouldn't exist. Nike is another example, and this is really interesting. They initially used to be something else, Blue Dot, Blue Dot, I can't remember the full name. They rebranded to Nike in 1971. Now, the interesting thing is they paid $35 for the designer who came up with the swoosh design. But Nike did not view that logo, the swoosh, as a $35 item. They realized that it is an important asset to this company that they will build equity in. So they filed the trademark 8 months again after their launch. So this is extremely important to realize that just because you paid $35 for your trademark does not mean it's worth $35. The value is much more. And today Nike's brand with the swoosh is I think it's 2.6 billion, something along those lines. Under Armour, they filed the trademark 1 month before launch in August of '96. In that year, they only sold 500 shirts, or total of $17,000. Now, if you start a business in the UAE and you sell 500 shirts in that year, that's nothing. But if you consider the market in the US and you sold 500 shirts, you know, that's pretty much a zero. But yet they filed a trademark in the first month. And Bershka, a bit extreme, they filed it 5 years before they're launched. The point of this is that you should not wait too long to file for your trademark or your IP in general to protect it. And where possible, do it before you start your business as well. What is intellectual property? No matter what business you are in, whether you are providing a software as a service online, or a nail spa, or you're selling or manufacturing clothing, you have at least a minimum of one IP. And these would be trademarks, TMs, copyrights, patents, industrial designs, trade secrets, which is something I'm not going to really discuss today, and other rights as well. I'm not going to get into, but I will briefly give you an idea about them. Like any other property that you might have, intellectual property can be sold or rented. So it could be assigned or licensed. And this is extremely important to keep in mind, because if you have not taken the steps to register your IP, then you would not be able to sell it. You will not be able to build that equity into it, or to license it. And there are a lot of companies around the world that generate a massive amount of revenue through licensing. Give you some idea, Ford, the car manufacturer, licenses its name to a company that manufactures drills and electric saws and things of that nature. Of course, Disney licenses Mickey Mouse and their characters to companies that put them on T-shirts and sell them. So it's limitless that what companies can do with their intellectual property. Boeing licenses its technologies to other companies. BMW, so we're not always talking about trademarks, BMW licenses some of its engines to other car manufacturers. And so that's additional revenue for them to recoup expense that they have invested into building, whether the trademark or the technology. As I said, IP is protected by local laws in each countries, but also by the international agreements that most countries have signed as well. And obviously this allows the creators to gain recognition and financial benefit for their efforts. So paying attention to your IP is extremely important, because IP represents, as I mentioned, one of the most important assets for any company. If we look at Amazon, for example, Amazon's trademark is valued at $200 billion. This was in February of 2020. Keep in mind, the trademark was filed in the same year they launched, when Jeff Bezos was not going to the moon. At that time, he was some guy working in his basement with a tiny desk. And yet he filed a trademark that same year. Today, it is worth 200 billion. That's not the company. The company, I think, is valued at 1.something trillion. But just the trademark, if you are to buy it, without their facilities, without their trucks, just the trademark name, you will have to pay 200 billion for it. Apple, another example, they filed their their first patent in 1997 when the two Steves were still two little kids sitting in their garage, in their parents' garage. They filed the first patent, and now the company has 10,000 patents. Now, if you think that if they hadn't filed their first patent for Apple II, that company wouldn't be around probably today, and we wouldn't have all the benefits of the inventions, and the products that they have developed. And lastly, industries protected by copyright bring $500 billion in revenues to the US economy. When we say industries protected by copyright, we're talking about movies, music, software is generally protected by copyright. So you can see the importance and benefit of IP, not just for individuals, but also for an entire economy. I mean, $500 billion in revenue on copyright. You can just imagine the 100,000 jobs that this would bring to the labor market in the US. We're going to start talking briefly about trademarks, which all companies in general have a trademark. You might not have a copyright, you might not have a patent, but a trademark for sure you have. So what is a trademark? In essence, a trademark can be almost anything you can think of that can act as a signifier of source of a product or a service. So when you go to buy a mobile phone and you grab a Samsung phone, you see that trademark, that name on it, Samsung, you know, okay, so this is that Korean company that is very creative, that builds very high quality products, and they always introduce new features, and this is the phone that I want. It's more expensive than the rest, but I recognize that trademark, and this is what I want. Somebody else might see the Samsung and say, no, I'm going to go to this other brand, that trademark. Because that trademark or that brand, I recognize it to be a more lower priced. It doesn't have all the bells and whistles, which I do not need anyway. So this is how you come to recognize these products or services, is by the trademark. And it could be a phrase, a letter, a sound, even scent or shape. So the Coca-Cola bottle, for example, is registered as a trademark, that 3D design of the bottle, because even if you see the bottle from a mile away and it doesn't have the logo on it, or you cannot see the logo, you do recognize it as a Coca-Cola bottle. So it is acting, the shape itself is acting as a signifier of the origin of the product. Aspects of packaging can become trademarks, and that, if you see the Tiffany box, that's registered as a trademark in jewelry sales. That color, the color combination with the ribbon, those are protected as a trademark. And actually, Tiffany sued Walmart, I think about 4 or 5 years ago, because Walmart started selling jewelry in their stores and giving the jewelry in this very similar packaging. So they were sued and they had to stop it. Important thing to consider about trademarks is that they are jurisdictional. And when we say jurisdictional, that means if I file my trademark in the United Arab Emirates, then I am not protected anywhere else. If I want to be protected in Saudi, I have to file in Saudi. If I need protection in the US, I have to file in the US as well. And this is where you have to understand your business to decide where you want to file your trademark. It's not necessary to file worldwide. I mean, let's imagine I start a business in the UAE manufacturing the local Arab dress for men, you know, they call it the dishdash. it would make sense, obviously, first to file it in the UAE, but then maybe Saudi, maybe Kuwait, maybe even Jordan, because they also wear them in those areas. But if I say I want to file it in Brazil, that wouldn't make any sense. I'm not going to have any market in Brazil. Filing it would be just a waste of money. So you have to rationalize the jurisdiction where you're going to protect your trademark. And the most important thing to keep in mind, and going back to the beginning where I said, some business owners, they say it's an expense. Well, it's not an expense, first of all, but a trademark once registered is protected for 10 years. And you can renew it indefinitely for other 10-year periods as much as you need to keep that trademark. Here, briefly, I'm gonna just explain the different types of trademarks, and they go from very strong or inherently distinctive to generic or not protectable. So a fanciful trademark, which is very inherently strong, is a trademark that you invent, that doesn't exist. It doesn't exist in a dictionary. So like Kodak, Exxon, FedEx, those are words that the owners came up with. They don't exist. Next, we have arbitrary, which is also very strong. An arbitrary trademark is when you use a word that exists in the dictionary, but you use it to very unrelated services or products. So for example, Apple for computers, they have nothing to do with each other. So that becomes very distinctive for computers using Apple, and that's a very strong trademark. Quickly to jump at the other end, generic. Now, if you use Apple when you are trying to sell apples or maybe even fruits and vegetables, that would be considered generic, and that would not be accepted by the trademark office, and you would not be able to protect it anyway. So Apple for computers, very strong, arbitrary, very good trademark. Apple for fruits, vegetables, or apples, generic, very weak and not protectable. And then you have suggestive trademarks. So if we look at Jaguar, for example, using Jaguar for a car, this is trying to suggest to your client or to their client some ideas about the car that they are selling. So when we think of a Jaguar, we think strength, agility, fast, things of that nature. So this is what the manufacturer is trying to imprint in the consumer's mind. And then this is strong, it's good. And then we have to the not so good, which is descriptive. And we see this a lot in let's say the UAE and in the region, where really what they do is just simply describe the trademark is a description of what they do. It is not a trademark in reality. One example is, if you look at the last one in the descriptive, frosted mini wheats. Now, I don't know how many of you are familiar with frosted mini wheats, the cereal. Frosted mini wheats are basically mini wheats that happen to be frosted with some sugar. That's really just a description. So that should not be considered a trademark. Now, what can happen is after years and years and years of use, it can gain something called secondary meaning, and it can become a trademark, distinctive on its own. Now, when somebody's looking at this and they're deciding, well, which one do I choose? Do I go with fanciful? Do I go with suggestive? Very briefly, it has to do a lot with the marketing budget you have. It has to do a lot with the expected life cycle of your product or your services. A fanciful trademark takes about 5 years and a lot of marketing efforts to build that name into the mind of the consumer. Kodak started in 1892. I bet you that had you gone to someone in 1900 and said, I bought a Kodak, they would have no clue what you're talking about. But today we recognize Kodak as the products, you know, the cameras and film, etc. So if you are offering something that you believe is going to have a life cycle of 3 years, it would make no sense to go with a fanciful trademark, because as I said, it takes about 5 years minimum to build that mind share with the consumer. But your life cycle for your product is 3 years. So maybe you should go with a suggestive trademark. So it would depend. And this is something you should discuss, you know, with an IP specialist as well, and considering your business demands. And the other important thing to do is you need to make sure that this trademark is available, because you might come up with a name, but then it turns out somebody else is using it, and that can cause problems for you. So you have to conduct a trademark search. And lastly, trademarks are filed according to classifications. It's called the NICE classification. There are 45 different classes. So if I am manufacturing clothing items, I would file under class 25. If you are producing fragrances, then that will be class 3, I think, 3 or 5, one of them. I think it's 3, I'm not sure right now. If you're starting a restaurant service, then that will be class 43. So you have to choose between all these classes. Now, I can tell you that some companies, their products could fall under 5, 6, 9 different classes. But then that means those extra applications. So you have to be careful with that. But why is paying attention to IP important? If you do not register your trademark, you will not be effectively able to protect your trademark. So if somebody infringes on your trademark, you cannot, in most cases, take advantage of the laws that are available for you to stop an infringement or stop counterfeiting. The other problem that can happen, and actually happened to a friend of mine, if you do not register your trademark, then it's available for anyone else to register that trademark. And once they register it, as far as the law is concerned, they are the owners of that trademark, and they can make you stop using it. So you will have to rebrand, and this is, as I said, exactly happened to my friend. He could have fought it in court, but it would have been very expensive and no guarantee he would win. So it is best to register your mark. And lastly, you risk losing the building equity in that brand and losing licensing possibilities. So as I said, building equity in the brand, like we said, Amazon, for example, it's worth $200 billion. What can they do with this? Well, I don't think they might want to sell it, but they might be able to, which is happening more and more, use it as collateral for loans. And instead of paying 9% interest on those loans, because Amazon is so stable and famous, they might end up paying 4% on those loans. So these are things that you could do. Also, licensing potential, you know, if you're not protected and registered, nobody's going to be willing to pay you money to license your trademark, you know, which happens a lot, let's say, in the fashion industry. A lot of the companies that manufacture sunglasses, the Gucci and all those brands, these are licensed to companies. So Gucci is licensing a manufacturer to build those glasses. Now, let's give you a real life example of problems that you could face if you do not take care of IP. Now, always when we're talking about intellectual property and trademarks, we tend to always think, I want to protect my trademark. I want to register my trademark so nobody infringes on my rights. But there's the other side, where you could potentially fall into legal problems because you are not, or you did not do your due diligence when it came to use your trademark. And an example, you all probably know the Microsoft OneDrive, which is the cloud saving sharing service. This initially was launched as SkyDrive by Microsoft. And when they launched SkyDrive, a company, a broadcast company in the UK called BSkyB took offense to SkyDrive for the use of Sky, because they had several marks with Sky, such as Sky Go, Sky Broadcast, something along those lines. And it caused problems for BSkyB. There were people actually confusing the two together. Somebody would call BSkyB and say, yeah, I'm having trouble with my SkyDrive. So BSkyB sued Microsoft in England, and the case took about 6 to 7 years to resolve. And finally, the decision was that Microsoft has to change the name. So hence they changed it to OneDrive. From SkyDrive, they paid £250,000 in compensation, and of course, whatever lawyer fees that they have expensed. Now, this situation happens a lot. Now, for a company like Microsoft, okay, it's effort and all that, but they have a lot of money. They have an army of lawyers. It's a problem. Obviously, they had to do the rebranding and everything. That's not cheap. But it is Microsoft. They have all the money in the world. But if you are a small company, just starting 7, 8 months, you got investments of 1.2 or $1 or $2 million to expand, and all of a sudden you're faced with something like this, and all the money has to go to defend or pay compensation. This could be disastrous. So always not only consider protecting your own IP, but also be on the lookout not to infringe on other people's trademarks. And this is where speaking to someone specialized in these issues is extremely important. So quickly, trademark do's and don'ts. Register your trademark as soon as you can. When choosing a trademark, have a few options. So if the first one might not be available, then you can go to your second preference. Very important, as we become much more international, keep in mind pronunciation and translation of a trademark in other languages. Chevrolet launched the Chevy Nova, which sold very poorly in Spanish-speaking countries because apparently Nova means no go. So they were trying to sell a car to Spanish-speaking people, and the car's name is, this car doesn't go anywhere. It's a lemon in essence. So be careful about this, and sometimes the translations are much worse than this situation. And you have to always consider the overall brand strategy of your business name and brand name. So to give you an idea, Tide, which some of you might know, the detergent, that is a trademark, but the name of the company is Procter & Gamble. So you have to understand your business and how it's going to be working, in combination with the other trademarks you might have, and how would you roll that out. So it's not necessarily that your business name has to be your brand name. This is extremely important to keep in mind. I give the example, if I start a cafe here in the UAE, and I've come up with a wonderful trademark, the Coffee Bank, okay? Now, if I go try to register my company as the business name as Coffee Bank, I will be refused because they cannot allow a company to be registered as a business name when it is really unrelated. There's something in the name that is unrelated to my business. I'm calling myself a bank, but I am actually a cafe. So let's say I will call it Victor Food and Drink Services Company. Now, I launch my business, I can register Coffee Bank as a trademark. That's allowed. And it will be owned by my company. And then that's the name I will use to market my coffee chain or coffee stores. So keep that in mind when you are setting up your business and issues like that. Let me see, I see here some chats coming in. Okay, we have some questions. I will leave it to later then. And once your trademark is registered, then you can enforce all the rights that you have available to you, and even taking action against infringers and counterfeiters. So this is extremely important. As I said earlier, without the registration, you will not be able to take advantage of most of these laws that are there to protect you. So this is very briefly on trademarks. So please, any questions you have for trademarks, write them down. At the end, we're going to go through some questions and answers. And we'll continue now to copyrights. Copyright is an extremely important topic. Copyright can be, as I said, okay, so anything you write, books, lyrics, music, software, pictures you take, movies, even databases are protected by copyright. The good thing about copyrights are they are protected immediately once you create them. So if right now I take a piece of paper and I draw something unique and original, it has to be unique and original. I shouldn't say unique, I should say it has to have some originality or creativity in it. And it is mine, then immediately, this instant, I will gain copyright protection pretty much worldwide without me doing anything. However, in some countries, you have the added benefit or ability to record that work with the copyright department in that country. We have that in the UAE. In the US, it is available as well. In the UK, they do not have that. So in the UK, you don't have a government body where you can go and record your copyright. US, UAE, we do. The benefit of this is that if in case there's an infringement, it is much easier to protect your or defend your rights. But keep in mind, recording it with the Copyright Office does not grant you any additional rights. And by not recording it does not take away any rights. Ideas are not protected, only the expression of an idea. So saying I've come up with an idea for a book, two people fall in love, that's not protected. Only when I write it, and that particular writing that I come up with is protected. Copyrights generally are valid for 50 years from the death of the author. Sorry, I had to bring that up. One thing I want to say, and let me just check the, okay. Copyright includes economic and moral rights in many countries. Moral rights are rights that you have to attribute the work to me if I am the one who created it. And then economic rights are the rights from where profit is derived. So these are two separate things. This brings us to here, who owns the copyright? Now, this is extremely important, especially if you are a business owner. Where you have people creating works that can be protected by copyright, if you don't have the proper agreements in place, your employee, as the person who created the work, could be the actual owner of that item that they created. So don't assume automatically that just because you pay me a salary and then you tell me, Victor, I need you to create something for my book. Go do this nice drawing. This is the concept I have. Go come up with something, and I'm going to put that on my cover. Now, if we don't have the proper agreement, I'm going to do this this drawing, and I'll give it to you to use for the book. Fine. Now you go take that copyright and that drawing and you decide it's so nice, I'm going to start making posters out of it. And you start making posters, selling it, I can come and sue you. Because in reality, as far as the law is concerned, in many countries around the world, including UAE, France, for example, in that scenario, I own the copyright and I did not authorize you to sell posters for that work. In a country like the US, that's considered work for hire, and immediately the rights transfers generally to the employer. But this also applies if, let's say, you are throwing a party or some event and you hire a photographer or a videographer and they film and take pictures. If you don't have the proper contract, you do not own the copyrights, they own the copyrights. So you have to be very careful about this. At the same time, you need to be careful when you are downloading images or videos from the internet. Because if you download a picture from the internet, most probably it is protected by copyright and belongs to somebody. And if you use it, they can come and sue you. Very brief example, just recently we started working with this photographer or videographer who does these drone filmings. And he's based in Paraguay right now. He travels the world. And he discovered that one of the television stations here in the UAE, in Dubai, used some of his footage in one of their news, what do you call them, like news bits. And because they can track these things, they have the technology to track these things. And he sent them a letter and had them pay $3,000 for that. Whereas if they had licensed it, they could have probably paid less. But these things do happen, so be careful. And if it happens to big TV stations, it can happen to you. And as I said on the last point, be careful when you're using outside agencies and service providers, because you need to make sure you have the proper agreements so you own the rights to the works, to whatever they are filming or photography. Is there real protection to copyright? Yes, there is. How are we doing on time? I need to move a bit quicker. Copyright infringement does exist in the UAE and around the world. So that's not just because, sometimes people think we are in the United Arab Emirates, so there are no protections. No, I know somebody whose photos were used by a big financial institution on a billboard on Sheikh Zayed. This is about 4 or 5 years ago. He sued them. When he asked them to pay $10,000, take it down, they ignored him. So he filed a case against them and he won 100,000 dirhams actually. So yes, copyright, obviously in a country like the US and in the EU, we expect that. But even here, these rights exist. So this is as far as copyright. Now, next we will come to what I have left is industrial design and patents. I will speak a bit more about industrial design because I think for most businesses this would apply more. So what is industrial design? Basically, industrial design is a right that you gain when you invest time and effort into designing something. So as you can see, the chair on the left and on the right, that's a lemon juicer. You invest money into this design, which has no purpose except to make it look nice. That's it. So really, it is your design has only aesthetic benefits and nothing else. If the design has an actual benefit, such as making the door handle operate in a more efficient way, then that would have to go to a patent. So for it to be an industrial design, it has to be novel, which means around the world, this has never existed before. It has to be original, and to file for the protection for copyright for industrial design, you should not disclose it before you file the first application. Okay, so for industrial design and patents, you file your application for protection and then you disclose the IP. Unlike with a trademark, the trademark you can disclose it today, start using it, and file 2 years later. But keep in mind that this has to be the design has to be for products that will be produced on a mass scale. So if you, for example, the lemon juicer, you've come up with this design and you're only making this one piece, nothing more, then that's not going to be considered industrial design. That would go more, I think, to applied arts in the copyright. That would be protected as a copyright if it meets the conditions. Why do companies do this? Because obviously it helps them to sell more by, if you look at the Nespresso coffee machine, that unique design, that's an industrial design. It could have been just an ugly brown box. It doesn't have to look nice with the designs that they've come up with to dispense your coffee or for the coffee to taste good. But they invested that money to make it unique to help them sell more. So that design really has no purpose but that it looks different and looks good. So industrial design can apply to practically anything you can think of. Mobile phones, chairs, as you saw. The car hoods, those are also can be protected by industrial design. Lamps, door handles, anything. Also, industrial design can help protect patterns on fabric, okay? Industrial drawing. So when you think of the Gucci, is it the Gucci with the 2 lines or 3 lines? There's no creativity in that really, but that pattern is protected as industrial design, okay? Saying that it is copyright protected, not really, because I just brought 2 colors and I made 2 lines next to each other. So these are the type of things that you need to consider as well. And as I said, it cannot have a function other than the aesthetic purpose. Generally, around the world, you have to file to get protection for your industrial design. In some areas, such as Europe, UK, India, you can gain rights for unregistered rights, but they would be much shorter. As an example, in Europe, if you register your industrial design, I think you can go up to 25 years protection. But if it is not registered, it's 3 years. 3 years, 5 years, but it's in any case, it is much shorter than what you can gain with filing. And design has to be original, novel, and non-common, which means new. Okay, and we're almost there. Very briefly, patents are basically inventions of products. You invent a new mousetrap, more efficient, that's an invention. You invent a method to desalinate water using half the energy that what is used today, that's an invention. Actually, we had filed a patent for a client from Singapore. They invented, or they came up with a process to make bricks for homes where they actually absorb the CO2 from the rooms, so it keeps it healthier and cleaner. So it was a process, not a product, in essence. So it can apply to almost any machines, manufacture, composition, composition of matter such as medicines. Those are protected by patents. And patents usually are protected for 20 years from the date that you file. Very important to keep in mind, if you do invent something, do not speak about it until you file your application. If you talk about your invention, then and then you file, you will not be able to claim rights to the patent. It can be expensive to file a patent depending on the nature of the invention. So you try to license it or work with other companies. And as I said, it is protected for 20 years. You have to maintain patent annuity payments, which is every year you have to pay renewal. One thing I will say lastly on the patents, and I think this is going to be the last one. When we talk inventions, don't think of rockets to the moon. An invention can be something so simple that has a benefit. So I'll give you a quick example. In Sweden, the mounted police, their horses used to damage the cobblestones in Stockholm, in the old city. So this person came up with a rubber shoe instead of using the metal for the horses, just a rubber shoe for horses. And it helped meet the requirement that, you know, it eliminated the damage to those cobblestones. It was something new no one had come up with before. And so he had a patent on that. So it could be something really simple. And the takeaway here, IP is not a cost. It is your most important asset, whether it's something you invented, your copyright, as we've seen the amount of money it brings to the US economy, your trademark, always protect it now. Don't wait, because you can get into trouble in the future. And it can be a source of revenue where you can license, you can franchise, or you could sell the IP when you're tired and you want to retire. And last thing I will tell you that right now, when you're starting a business and you're looking for investors, they're all asking you, what have you done with your IP? Have you protected it? A friend of mine right now, they started a business, not right now, they started about a year and a half, 2 years ago. They're called LVL Wellbeing, doing really good. Some major international banks have invested about $1 million into them. Insurance companies, high net worth individuals have pumped a lot of money into them. But always the question is, what have you done about your IP? And now we are helping them in protecting their intellectual property to make sure that it is there and it is an asset. So that's the end of my presentation. I see there are some questions here, and I think somebody's going to be assisting with this. Yes.
Yes, Victor, would you like me to read them out? I can start. So I can, the first question we have is, would you suggest for a bootstrap tech startup to go for trademarking their process or technology? Which are unique?
Well, you cannot trademark a process. Okay, so as I said, a trademark is the way people recognize your business. Okay, so whether it's a McDonald's, whether it's the Coca-Cola bottle. So if we're talking technology, then probably you need to be looking at patent. Did I understand the question correctly?
So this is from Kanan. So let me read it again. Would you suggest for a bootstrapped tech startup to go for trademarking their processes? And process.
Yeah, you cannot trademark processes. If you have processes, as in from within the software, then maybe there could be a patent there. Usually patents are copyright protected, but there are many instances where it could be protected as a patent.
Okay. So just on that one, Victor, so McDonald's, for example, they would not have patented their process of making burgers or how they serve to customers. That would not have happened. You cannot
protect that. We're gonna cook the burger, we're gonna put it on a bun, put 2 tomatoes on top, each burger gets 2 tomatoes. You cannot do that. There will be trade secrets, probably, no doubt. I mean, their recipe for the burger is definitely protected by trade secret, just like the Coca-Cola recipe is.
Right.
But to say, I'm going to protect how we're going to make a burger, you cannot do that.
Okay. Okay. Thank you. We have another question. And this is how it goes. Our mission is to get children to fall in love with books. We don't create our own content, but we curate books. We have a strategy to pick these books and support teachers with lesson plans and activities to conduct these classes. My question is, what do we get to protect? What do we get to protect our IP? Do we have to get a copyright for our lesson plans, or patent our pedagogy and strategy of curating books?
So basically, you say, when you're saying curating, meaning you are buying books in essence?
They're selecting the books. They put together I think the selection of books.
Yes, but these are books that already exist, written by somebody, and then you are developing. Okay. So as far as getting copyright from the original authors, you don't need to do that. You don't need to get permission, because those books are available for sale. Now, what you're describing could be very simple, or compared, let's say, to a university, where the university picks from different publishers and different authors in different topics. So they will say, okay, for this class, this book is assigned, etc. So unless you are developing your own training, let's say training material, then all you would have that I can see is your trademark. But if you are not just relying on the books that you are buying, but also if you're developing your own training manual, let's say, it depends how original or creative it is, if it necessitates getting a copyright. What I mean by this is, if I choose 3 books to train children, I find them in the library, and I go, okay, yeah, these are great books. And then I say, okay, what I want from the kids are to read this book, and then read this book, and then read this book, and then we're going to do a test. There's not much to protect there, as far as I am concerned. So it would depend. I would need to understand a bit more about how exactly you're doing this.
So Victor, are you saying that it has to be creative, it has to be unique? Like the question is related to lesson plans and pedagogy, the methodology of teaching. If they already exist and they're not unique, I guess they can't be. There's nothing to protect then.
Exactly. Now, maybe their methodology, the way they are writing it, that can be protected as copyright. But remember what I said, in copyright protection, ideas are not protected. The expression of the idea is protected. So if we take Romeo and Juliet, assuming the author, can't remember his name now, I've been talking for too long, is alive still, and there is copyright.
Shakespeare?
No, William Shakespeare, thank you very much. No one can stop me from writing a story that also deals with 2 people, young people who fall in love, whose families are not on good terms, they hate each other, and then the 2 lovers commit suicide by jumping from a bridge. Okay, but his words, the way he's written it, is protected. So this is why when we're talking about syllabus or training manual, it would be hard, and we'd have to look into it to see exactly.
Okay, thank you. I have another question which is related to registration of trademark in India. And it says that I have a registered trademark in India. If I wish to register in the US or UAE, and there is already an existing brand there, what happens to my brand? What are my options?
Okay, so depending on the facts, you could face problems in trying to register your trademark in other countries. Now, as I said, trademarks are jurisdictional. So when you are registered in India, you're not protected anywhere else in the world. So you cannot stop someone in the US of filing the same or similar trademark. Maybe they came up with it independently. Two things I will say to you. There is something called priority. Priority, what that is, if I file a trademark in the UAE today, I have 6 months from today to go to almost any other country, including India, file the application there and claim priority. In effect, what that means is, let's say I've registered Victor Sonics as a trademark for speakers in the UAE today, which is, what is the date today? The 25th. Now you in India go register the same trademark in India on the 26th, so tomorrow. If within 6 months from today, I go to India and I submit my application for the trademark and I claim priority, then my trademark will be considered to have been filed in India a day earlier than your trademark. So you filed on the 25th, on the 26th, when I submit with the priority in India, then my trademark will be considered filed on the 25th. So my application takes precedence over yours and your application will be rejected. But it has to be done within 6 months from the original filing that you have made. Now, the other issue to consider is, especially considering there's a lot of business relations between India and the UAE, who filed the trademark in the UAE? First of all, did you file first in India and then they filed in the UAE? So that's one. Second, is there a business relationship between the both of you? There are situations where you can file for the cancellation of a trademark if you can prove that it was filed in bad faith. So let's say you are in India, you are selling rice to a distributor here in the UAE. And this distributor, without your permission, filed the same trademark here, which can cause you a lot of problems when you're trying to expand. So that could be considered bad faith. So you can ask them nicely to cancel the application or the registration. If they do not, then you could file for a court decision to cancel it based on bad faith. So there are possibilities.
Okay, thank you. I have a question here. This is how it goes. My brand name is Vanaras, Vanaras, Vanaras. We registered the trademark and there were opposition from different companies, including Vans, apparently with a capital V.
Mm-hmm. I think they make shoes.
Oh, Vans, the shoes. Correct. Mm-hmm. We did reply to Vans with all the legal documents, but they haven't got back at all. Is there a time period by which they should reply? And if they don't, does that mean their opposition is cancelled?
No. Okay, so I'm not sure what country you are in, but generally each country, what happens is once your trademark is published, any third party with good cause can file an opposition against your trademark. In the United Arab Emirates, we have 30 days. So let's assume your application's in the UAE and it was published and Vans filed an opposition against your application. You have 30 days to respond, not to Vans. You have to respond to the trademark office. If within 30 days you do not respond to the trademark office, then they will consider that you have elected to abandon your trademark and you will lose your application. Now, that doesn't mean that you cannot try for the first 2 weeks, once you receive the notice, to contact Vans. But even if Vans responds to you and says, oh, you know what, it makes sense, sure, no problem, we're gonna allow you to do it, and you don't respond to the trademark office, you're still gonna lose the application. Now, some jurisdictions such as in the EU, what they do is they do, I think, initially a 2-month cool down period. They call it something like that, where they try to let the parties resolve it between themselves, but then you still have to go to the trademark office to notify them. So, I don't know where you are. When did you receive this this opposition notice? In some countries, you have 60 days to respond. In the UAE, it's 30 days. Some places are 45 days, so it depends. So you really need to look at this, and you really need to respond to the opposition.
Okay, because it doesn't say from where she is and how long it's been. Okay, okay. The same person is asking, what is the difference between a logo with TM in inverted commas and a logo with the R symbol?
Okay, so R means it's registered, a registered trademark. TM simply means it's a trademark. Maybe it's registered, maybe it's not. Now, you cannot use the R unless you are actually registered. So when you launch a business, if you haven't filed for your trademark, or even if you filed but it's not registered yet, filing is not enough, you can use the TM. Now, once the trademark is registered, you have the option. You can keep the TM, or you could use the R just to give it more strength in the market. Because the whole purpose of the TM or the R is to tell other competing businesses, for example, is that this is my trademark. I own this. This is my property. And I am building equity into it. And if you copy it or if you infringe against my trademark, I will take action against you. And it is important to note that in many cases, where if you don't use the TM, this could go against you in a court, because they will say, well, you weren't notifying people that this is a trademark. Okay, so it is always good policy, at the least, use a TM.
Okay, thank you. We have another question here related to business model protection. So can a business model be protected with IP? If yes, then what kind of IP? Is it related to patents or copyrights? And the question continues, the business model is differentiated in the software platform we provide. In that case, can be protected with an IP?
Okay, copyright, no. Copyright protects things such as work of authorship, pictures, drawings, software. The coding of the software is protected, but not business. You said business models, yeah, was the question? Business
Yes,
models.
can a business model be IP protected? Yes.
Business models with software were receiving protection in the EU and the US up until some few years ago, where there was a case called the Alice case, or the Alice test. And since then, it has not been as easy to gain protection for business models with software. But a business model, pure business model, such as saying, I've discovered that if I'm selling cars and when people walk into the showroom, if I turn on the lights off and on, for example, 3 times, and have the phone ring 4 times and then ask them to buy a car, they're more inclined to buy it. Something that I've discovered from 20 years of working in this industry, that in itself is probably not protectable. And as I said, if it's with a software, possible, but it's just getting harder and harder.
So Victor, on that point, like Uber, when they set up the company, they would have trademarked their name. But I guess the process of the platform, they couldn't do anything, because then there's Kareem and there's Lyft and there's so many others.
Very, very good point. Exactly. See, take Uber, that's fantastic. Uber, first of all, they have their trademark, Uber That's a registration trademark, you protect it. What else do they have? They've developed the software that they are using. So that is copyright protected. But because I am confident that because their software, well, it does actually, their software is interacting and managing the driver with the maps, with the direction and payment system, then probably no doubt they have a patent on some parts of this, or they have licensed patents from other places. So if there is Lyft, the other company, Lyft, Lyft. So when Lyft comes on board, Uber cannot stop them from coming up with the same concept. Hey, why don't I do an app where people can use it to rent their cars and we drive them? That as a business model. Now, I cannot copy the coding of the software, and there might be some features I have to change in order not to infringe on their patents if they have any. But you cannot stop them from following the same business model.
Mm-hmm. Interesting. Thank you. So we have a question related to food products now, very interesting. So it says, when we talk about food products, in case of flavors, we might first start with one composition, and later with the response from customers, we may change the composition. If we file for an IP for the earlier composition, will we have the feasibility of changing the composition, and will the IP be still applicable?
Well, look, when we talk about, when you're saying composition for food related items, you're talking in essence recipes, and recipes are not easy to protect as a copyright. But going with your example, if you had come up with something that in your country they accepted it as a copyright, then that just remains. Now, when you make a change, file a new one, file a new copyright and leave the old one. Because first of all, I don't think you can change a copyright. You'd have to file a new one. But even if you could, then you leave the old one open for anyone else to copy. But I'm not so sure that these type of recipes can, in general, receive copyright protection.
Interesting. Okay. There's a question here about the objection of a trademark. If the status of the trademark is objected after a year, what needs to be done about it?
Sorry, repeat that question.
If the status of the trademark is objected after a year, what needs to be done about it?
Well, as I said earlier to a previous question about the opposition, when you say objected, I assume you're not talking opposition, because there's two ways you can have problems with the trademark. Is that the trademark office itself, the examiner, who's representing the government in essence, might not accept your application and object to it. So they might refuse it or ask for certain changes. On the other hand, an opposition is made by third parties. We mean third parties, meaning it's not the trademark office itself that is raising issues against your application, but outside parties. So it could be another business owners, with the vans scenario. If it still says objected, then you should, based on this, still have time to take action. So you need to understand what is the problem. First of all, is it a third party that filed an opposition, or is it the trademark office that is raising issues or refusing my application? And usually in all these cases, you have the right and the ability to appeal. You can appeal to the trademark office, and Even then, if it's rejected again, you can appeal.
Sorry, Victor, sorry, I'm just going to interrupt there. She's come back and said not opposition, it's an objection.
Objection. So from the trademark office. So if it's still saying objected, then you should still have time to appeal that objection. So you need to understand what are the reasons that the trademark office raised. Is it they're saying another trademark exists that is similar? Are they saying it's generic? Remember, we talked about that spectrum, the strength. Maybe you've called your trademark something that for your industry is considered generic. That's why they are refusing it. Maybe they find it offensive. So you need to understand what is the problem. And usually you are supposed to receive notification from the trademark office that says, we are raising this issue related to your trademark because of 1, 2, 3. And you have X amount of time to respond, or else your trademark application will lapse and you would have to file again. So you need to see what the story is with the, you should have received a letter or notification.
Mm-hmm. Okay, there's a question here about so then she says, so if it is done through an agency, we need to go through the same right, she's asking. We have not received any information from the trademark office directly.
Okay, yeah, so you're working with an agent, they file a trademark on your behalf, they submit the applications, and when this issue happens, they send it to your agent. Yeah, they don't send it to you directly. It gets sent to the agent because they are the people who submitted the application. Now, your agent is supposed to come back to you and say, we have received an objection or a refusal on your application. The reason for the refusal are 1, 2, 3, and usually they should also attach the notice of objection. And then they should inform you that you have until this day to respond to the objection. And in our opinion, when we do this, we might say, in our opinion, let it go. You're not going to win this objection if you file an appeal. Or we might say to you, in our opinion, this objection is wrong, and definitely you have a very good chance of winning the appeal. Our recommendation is for you to proceed. What do you want to do? Because of course there's cost related to it. We have the same situation right now in Saudi for one of the biggest electronic companies in the world. We filed a trademark for them. They came up with a trademark that I want to say shares some letters, but our client's trademark has like 6 letters, the other one has 8, and they're so different, like the structure, the beginning, the end. And they rejected our client's application. And we completely disagree with them. So we filed an appeal at the trademark office. Again, they rejected it. And I have to say, sometimes Saudi trademark office comes up with weird decisions. And now, tomorrow, actually, we are filing an appeal with the commercial court in Saudi. And I am 99% confident we're going to win it. So this is what has to be done. And just to also like wrap up all this together, one of the problems, not just the name that are supposedly similar, which they are not. One, our client has software to control home automation, Internet of Things, so you can turn on the lights when you're outside, you can start the dishwasher. The other company is some software used for pharmaceutical research, pharmacy, biotechnology. I mean, they are so different. There's no way that these two can be confused. So these are the things that should be, that your agent should be telling you. and they should make some sort of recommendation. I hope that answers. I went a bit too long on this one, but I hope that gives you a good idea.
Just a clarification, Victor. So she has to go through the agency. She can't go directly to the TM office.
Okay, so you can yourself go file your trademark in the country where you reside. Okay, but so I live in the UAE. I can go and, well, maybe I'm a wrong example. You reside in the UAE, Shabana, and you started your business. You can go to the trademark office and file your application yourself. But if you want to file in Saudi, if you want to file in the US, although you can afford the flight and you can fly to Saudi and say, I want to file my trademark, they're going to say, do you have a business here and address here? No, you cannot. You have to go through an agent. You have to. So in your country of residence, you don't have to. In a country where you're not a resident, you don't have an address, you need to use an agent. Now there's something called Madrid system. Madrid system allows countries that are a member of the system to file through their own country in the other members. So for a lot of the countries in the Middle East, they are not members. Right now, I think there are 88 companies that are members of Madrid. So let's say you reside in the US, you file a trademark in the US, and then you tell the US trademark office, add for me these 15 countries, submit applications there. And the USPTO will act on your behalf and send to those countries. Of course, you have to pay. It gets a bit complicated. There are pros and cons to it. So it would depend on each situation.
Sure, thank you. And then I have a question. In India, after applying for a trademark for a company, how long does it take to get the approval for the same? Company has been registered as LLP, but trademark with the same name is yet pending approval. How can this be expedited?
Well, I know in India it takes, I mean, if everything goes smoothly, I think for the application process to go through maybe 3-4 months. And then after 3-4 months, it gets published. I think there is 4 months opposition period. I can't check now. I just received a notice on an application in India. I think it was 4 months. It'll take, I would say, minimum a year in India.
Okay.
Maybe 1.5. So that's the thing. It depends on the country. Some countries you might go through the process if there are no objections, no oppositions. In the UAE, it can take as low as 6 months, 7 months. In Qatar, it takes 2.5 years. In the US, takes 10 to 12 months. So it depends on each country, the workload, things of that nature.
And Victor, where would be the best place to find this out from? Is there some place, a good source on the internet, or do you need to
to find what exactly?
This kind of information that you just listed, the time frame, for example.
It's hard to say that there's one place you can find this, and usually this kind of information is kind of fragmented.
Right.
I mean, we have a spreadsheet where we try to keep this for as many countries as possible. It's hard to keep up on a updated basis, but we try to keep that as relevant as possible.
Right.
But yeah, you might find some places, but it still won't be that simple to find.
Okay. And then we have.
Sorry. Just to be clear, if you're looking for one country, yes, you could just put opposition period trademark application, India.
Mhm.
But like if you want all countries or number of countries, it's not that simple. But these are the type of information we provide to the clients.
Sure, sure. And then I have a question related to patents, which is for patent validity is 20 years from the date of application, as you. So the question is it 20 years from the date of application of the provisional specification or from the date of grant of the patent?
Provisional specification, you must be, are you in the US?
Does not say, interestingly, yes. Anonymous, this is an anonymous attendee.
Okay. Yeah, because usually provisional applications are in the US. So, okay, 20 years from the date of application, because most countries do not have provisional applications. I know India might have, I'm not 100% sure, but pretty much everyone else does not. You submit the full application on the date you submit your application. In essence, just for the rest to know, provisional application in the US allows you to submit, let's say, a stripped down application, and then you have 12 months to turn it into a full utility patent application with all the proper required documentation. Now, the EU does not consider the provisional application as anything special. So for them in the EU, so for the US, they will start from when the time you convert it within those 12 months. But in the EU, they're going to look at your provisional application as the original application date. So again, it will be 20 years, but each jurisdiction is going to look at it differently.
Okay, Victor, we'll make this our last question. We literally have 2 minutes, and I think it's an important question. And you may have already answered it. Please say so. How could we get software, product, trademark, copyrights, and protection?
So, trademark, okay, if, just to give a quick example would make it easier. So, if you are a company based in the UAE, let's say, and you've come up with you're a software developer and you've come up with this really nice software that people will be it'll be very useful for people, you can sell it. So first thing you're going to do is you're going to name it, right? Such as Excel or Photoshop, right? That's your trademark. So you probably will need to work with an IP agent because it gets complex, right? Especially that something like this, you're not just going to sell in the UAE, you're going to sell worldwide maybe, and in other regions. So you have to work with an IP agent to check the classifications, make sure there are no similar trademarks to what you've come up with. Remember the story about SkyDrive? You've come up with this wonderful name, and when you launch your product, turns out some big software companies using that name and they come and sue you. You don't want to face that. So you need to work with someone who's going to figure out what class do you fall in under the niche classification that I had mentioned earlier. Is it available really to use? Somebody else hasn't filed it. And then in which jurisdictions do I want to file it? This is the trademark. Copyright. The copyright, once you create the coding, that's protected by copyright automatically. But it is very smart if you live in a country that allows you to, UAE, in the US, where you can submit it as well with the Copyright Office. So in case somebody copies your coding, you can take action against them. It'll be simpler, easier, and quicker results. If your software has the added feature that it has, let's say, a real world effect or controls machines as well, then you could have a patent also in the software. And whenever you have patent in a software is 100 million times better than copyright, because copyright protects what you've typed, right? But it doesn't stop somebody from coming up with something similar. Whereas if you have the patent, you might be able to stop people from coming up with something similar.
Okay. Okay, Victor, I think we'll have to end on that question. Thank you very much. A very
My pleasure.
enlightening, interesting. Thank you.
Good.
Is there any way if people have more questions that they can contact you? How would you, are you
I think the best way they can contact me on my email, if all can see it, victor.siriani@avidip.com.
Okay, okay. Thank you so much. Thank you. Take
My
care.
pleasure. Thank
Bye-bye.
you. Thank you, everyone.
Bye-bye, everyone. Thank you.
Thanks, Victor. Thanks, Shivana. Thanks, Shamima.
Thank you all. Bye-bye.
Thank you very much, Victor.